Alex here with part 185 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version answers the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into an ex parte motion, I believe, that's the next video. In this video, we go into my replies to my ex's attorney's oppositions to my motion. I can remember now. So in the previous video, we went through their oppositions, which, if you guys can remember, they were very terse. They didn't contain any affidavit in support. It was just something along the lines of, we can't talk to our client, and so we are just doing the best thing we can as attorneys, and we're opposing this, I guess you could say, arbitrarily, in the hopes that the court holds a hearing and gives her an opportunity at the hearing to explain herself. So this video goes into my replies. Now, my replies are more elaborate, but they are clones with one teeny tiny exception. So for that reason, I'm going to break my rule again, and rather than do the replies in two separate videos, I'm going to just do both replies at the same time right now. And when it comes to the difference between the two, I'll discuss it briefly. But this is a video that I think a lot of people are going to be surprised about. I know I was surprised to see the outcome, actually. Maybe the video itself won't be as surprising as the outcome, because I do end up winning summary rulings, which is a ruling without a hearing. It's in my opinion, as a non-attorney, the best type of decision that you can get is a ruling in your favor without a hearing, because hearings are so stressful for us. We're not lawyers going in there, facing the court, face to face, speaking. We don't have necessarily the best speaking skills or the best debate skills like attorneys have. And so when you win on the paperwork, it's like the best thing in the world. And that's going to happen a few more times in this case. Most of the time, I think a lot of us lose on the paperwork, and then we're like, dang it, it would have been nice to have a hearing to at least explain ourselves. But I mean, after you've done this for a few years, I remember in the beginning I liked hearings, and then towards the end, like around year 3 or 4, I changed my mind. I was like, I don't even like these hearings anymore. I just want to just do everything by paperwork, because I feel like I can explain myself a whole lot better in writing. If I mess something up, I can just hit the backspace key. You can't hit the backspace key when you're in court talking. The last thing I think I'm going to mention is my mindset, which was maybe a little bit annoyed, but I think it was mostly positive. I felt like I had some really good arguments to offer the court. I felt like I had an opportunity to really use the law against these people that are supposed to be experts in the law. And you're going to find when we go through my documents that that's exactly what I do. I really do nail them to the wall with a series of statutes and court rules to force this outcome to be not only an outcome in my favor, but to be a summary outcome in my favor. All that being said, let's go ahead and take a look at what I have filed. Here we have my reply to opposition to omnibus motion to establish a continuing duty to disclose physical residences, medical, dental, etc. If you guys can recall going through the motion, you'll remember everything that it is that I'm looking for in this motion. Scrolling down, and I have my standard introductory paragraph introducing myself to the court as the petitioner and the father, indicating that I don't have an attorney and I am representing myself. Memorandum of points and authorities. My ex appears to be unwilling or unable to communicate with her own attorneys. The instant motion pending before the court alleges that she is unable or unwilling to communicate with me. This has placed her counsel into the unfortunate position of putting forth an opposition that merely seeks to preclude the court from deeming my motion meritorious under Rule 13 sub 3. My response is then to cite Rule 13 sub 3, which states, within 10 days after the service of the motion, the opposing party shall serve and file his written opposition thereto, together with a memorandum of points and authorities and supporting affidavits. That is the crucial part of the rule that I'm going to use against them. If any, stating facts showing why the motion should be denied. Failure of the opposing party to serve and file their written opposition may be construed as an admission that the motion is meritorious. Now, they do mention that final part there because they're concerned that by failing to file an opposition, that the court's going to deem my motion meritorious and just grant it. Under this rule, my ex failed to file a timely, had my ex failed to file a timely opposition, it would be within the discretion of the court to deem my motion meritorious and to grant it. However, the mere labeling of a pleading, by the way, guys, it's not a pleading, it's an other paper. If you want to learn more about pleadings and why there's a distinction in Nevada, please watch my video on the topic pleading. Sorry, let's go ahead and rewrite that. However, the mere labeling of a paper captioned opposition does not necessarily preclude the court from exercising Rule 13 sub 3 in the instant case. And then I go ahead and cite this case law titled Nevada Power Company versus District Court, where they state in that case that the court must look to the substance of the claims, not just the labels used in the amended complaint. Now, it's not exactly on point with what we're talking about here, but the point is that the court has to look to the substance of the document to see if it actually is an opposition. The court can't just look to the caption or the title of the document, and since it says opposition, it is one. The court actually has to read it and find out, is this actually an opposition? My ex merely cites Rule 13 sub 3 and recognizes the perils of failing to file a responsive paper. My ex fails to actually file points and authorities and supporting affidavits that directly controvert the asserted facts and authorities set forth in my motion. And then I go ahead and explain to the court what the purpose of this all even is. The purpose of the motion, opposition, and reply is to adequately brief the court on the issues raised and the arguments made. The court has the discretion to summarily deny a motion where the movement fails to set forth a prima facie case that establishes good cause for a hearing. And then I go ahead and cite Rooney v. Rooney, which is exactly that. In that case, they explain that if you don't set forth a case, then we're not even going to set a hearing. There has to be a point to the hearing. If it's completely pointless, then based on the paperwork, since it's pointless, they're not going to set one just to make you feel better. They're going to just summarily deny the motion. So I also go ahead and give the court an example to summarily grant a motion where the non-movement fails to offer the court any subject matter upon which it could properly decide after a hearing that the movement is not entitled to the relief requested. Rule 13 sub 3 again, but more importantly, Lippis v. Peters, which is a case involving, if I remember correctly, summary eviction. And in that case, the Supreme Court stated that if an issue is not raised and brought before the court in some manner, then there is no issue to be heard. And let's go check that footnote really quickly. Lippis v. Peters. Okay, yeah, this is a summary eviction case. So in this one, they said, quote, for example, one of the tenants in this case presented as a defense the proposition that her daughter needed a wheelchair and medication and that they were unable to pay January rent. The daughter did not get her SAMI card until the middle of January, and they can pay the rent up sometime this month. Just can't say what day. Unquote. The Supreme Court stated, as touching as this tenant's plea may be, it does not offer to the court any subject matter upon which it could properly decide after a hearing that the tenant was not in default of the payment of rent. Same issue here. Even though my ex has filed something, there's nothing in that particular something that she filed that shows this court that there's any issue to even hold a hearing on. So I go ahead and cite that case to show the court that it has the power to both summarily grant and summarily deny paperwork just based on the substance of the paperwork itself. It doesn't always have to go to a hearing just because somebody says so. So I'm going to go ahead now, and I think this pretty much wraps this up. The court is well within its discretion to deem my ex's opposition as an admission that my motion is meritorious, and it consent to granting the same. Here we have my verification under the law, which is swearing under penalty of perjury that this reply, all the facts alleged in it are true and correct. Rule 5 certificate of service indicating that this document is not, Rule 5 certificate of service indicating that this document was mailed to my ex's attorney. And that's it for that one. The reply to opposition to motion for order to show cause or for the alternative relief requested. So this document is a clone with one exception. I'm going to go ahead and skip down to that section, but what I'm going to say right now is, as with all my previous videos in my Docket series, if you ever have a question about a document that I glaze over, you can always go down into the description below, click on the link, download it for yourself, take a look at it, and if you see something that you think I should have addressed, please mention it in the comments below. This is with regards to a contempt motion, so I know that it's going to be in that area that it's addressed with. Here it is. This is the extra paragraph that I add. Nevertheless, I am merely requesting the court to order my ex to appear before the court and show cause, if any she have, why she should not be held in contempt of court. This will ultimately allow my ex a final opportunity to present and personally appear and explain her conduct. Under the circumstances, the court is well within its discretion to deem my ex's opposition as an admission that my motion is meritorious. So the reason that there is a hearing, the reason that hearings are mandatory for contempt of court is because they're pseudo-criminal proceedings. Depending on whether it's a civil or criminal contempt. But in this particular situation, it's a criminal contempt. And if you want to learn more about those labels, please watch my video on the topic contempt of court. Anyway, even if your opponent doesn't oppose, the court just can't summarily jail them. The court has to order them to show cause. And in fact, it's one of those awkward situations where normally if your ex doesn't appear to a hearing, you can just win. But when they don't appear to this particular hearing, you still can't just win. They have to issue a bench warrant. They have to find them, track them down, throw them in a jail cell, pull them out and drag them into court, similar to how they deal with criminal cases. So all of these things do not allow me to really win this contempt motion on the paperwork. So one of the other things that I wanted to mention is this is why I like to keep contempt motions separate from other motions, at least in Nevada. It makes sense. They're dealt with differently in so many ways. How they are appealed is completely different. As I mentioned, how they handle non-responsiveness is completely different. And so if I lumped both of these two motions together, the court may have been inclined to just say, I'm going to just set a hearing on all this stuff because I have to do it for the contempt anyway. But because I split these two motions apart, I'm actually able to get some relief quicker than I otherwise would have been able to get. So if you guys need to, I think I might talk about this in one of the videos, attack, but I'm not sure. I know that I do talk about the issue of whether you blob certain things together into one document or whether you separate them out. And it might actually just be in my Docket series that I do that, and I just can't remember where. But this is an example where you guys can see that I made a kind of a strategic decision to not lump the contempt portion of the relief that I was requesting into all that other, that omnibus motion. I kept it separate, and here's one of the advantages to it. And this does end up working out exactly as I'd hoped. I end up getting relief on the omnibus motion very quickly, and this motion I think gets delayed a little bit, it's fine because at least I get some relief now. I don't mind if I'm dealing with some issues with the judge. It's worse if I'm waiting around for everything to get resolved, especially in this particular case where my son is suffering because he's not getting the care and attention he needs. I'm going to go ahead and scroll down. Verification, same as the other document. This is all cloned. Okay, next document we have a request for submission. This is something you guys have seen probably a bunch of times by now. This is a document that just submits to the court for consideration the omnibus motion. If you want to learn more about the request for submission, please watch my video on the topic request for submission. A lot of jurisdictions don't even use this, but in the one that I was litigating in, it was required. So with this document, I'm submitting the omnibus motion to the court for consideration. Rule 5 certificate of service indicating this document was mailed to my ex's attorney. Then we have another request for submission, but this one submits to the court for consideration the motion for order to show cause, the opposition and reply. So same exact thing, but it's just submitting the other document to the court, the other documents. Rule 5 certificate of service indicating that this was also mailed to my ex's attorney. Going into the aftermath, I filed, it looks like, all 4 documents. Those were all free filings, so I incurred $0 in costs. My ex's attorney didn't file anything, so they incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have still had to review these documents, even though they were trying to withdraw from the case. And so I would say that they were, both the replies were virtually the same. There was probably 15 minutes at most. I mean, at this point in time, they're checking out anyway. I think it's reasonable to say it would take them about 15 minutes to go through these very quickly. And at the rate of $250 an hour, that's going to come to $62.50 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.